On February 27, 2026, in the Tumwater Municipal Court in Washington State, defendant Brian West faced a critical procedural hurdle that would test the boundaries of his constitutional right to a speedy trial. West, who had been scheduled to enter a guilty plea to unspecified charges, found himself unable to appear in court, not because he was unavailable, but because he was physically present in the very same courthouse, detained on an unrelated Superior Court matter. What began as a routine plea hearing transformed into a complex legal dispute over whether the defendant's simultaneous involvement in another criminal case could justify extending the government's time to prosecute him.
I can
Yes,
barely
Your Honor.
see. There we go. I just saw the top of your head over the computer. Your client is that Brian West?
Yes, Your Honor.
All right. So you're just waiting for him to be brought in then?
Actually, Your Honor, I mean, if my matter could be heard, I could sort of explain the situation.
Sure.
So, Mr. West intended to enter a plea today. He reviewed the documents. They are ready for you in the judge's folder. The issue is that Mr. West was transferred to Thurston County Correctional Facility on a Superior Court matter, which he's actually being heard in the booth right next door to me. But we were told that Mr. West will not be pulled for today's hearing in district court. So he's right here. He's not in another jurisdiction or any other county. His speedy trial waiver or speedy trial period has commenced on December 9th, 2025. Today is the last day of his speedy trial period. Mr. West is exercising his right not to waive his right to speedy trial. And so we object to Mr. West not being brought before the court today to enter his change of plea.
Can you tell me what's going on in his other case in the Superior Court courtroom?
From what I understand, it's a preliminary appearance.
Your Honor, it is not. It's a warrant return. Mr. West.
Defense counsel Ms. Haygood raised a speedy trial objection when her client Brian West, though physically present in the courthouse for an unrelated Superior Court matter, was not produced for his scheduled municipal court plea hearing. The prosecutor clarified that West was in custody due to a bench warrant issued after he failed to appear for an omnibus hearing in the Superior Court case. Under Washington Criminal Rule 3.3, which governs speedy trial rights in felony and misdemeanor cases, a defendant must be brought to trial within specific time periods, 90 days from arraignment if the defendant is in custody, or 120 days if released, unless statutory exclusions apply. The rule identifies multiple circumstances that toll or pause this clock, including under subsection A3, when the defendant is engaged in proceedings on charges in another court, and under subsection A4, when delay results from proceedings concerning the defendant's competency to stand trial or concerning the defendant's mental or physical condition. Here, the judge ultimately relied on CRR 3.3, a 3 to find an excluded period, reasoning that West's presence in Superior Court for pretrial proceedings on unrelated charges constituted engagement in proceedings on charges in another court. The defense's objection, preserved for the record, highlighted the tension between a defendant's physical availability and their legal unavailability when formally in custody on another matter. The judge also suggested that West's own conduct in failing to appear for the Superior Court omnibus hearing, which triggered the bench warrant, created a situation of his own making that could independently justify exclusion under equitable principles. This exchange illustrates how speedy trial rights, while constitutionally fundamental under both the Sixth Amendment and Article I, Section 22 of the Washington State Constitution, are subject to practical limitations when defendants face multiple pending cases. The ruling demonstrates that courts will prioritize orderly resolution of interrelated proceedings over strict adherence to speedy trial deadlines, provided the delay falls within recognized statutory exclusions. For defendants, this means that strategic decisions in one case, here, the failure to appear in Superior Court, can have cascading consequences that compromise procedural protections in another.
Conditions were imposed on a Superior Court matter. He was granted a PR release with pretrial services on December 10th. He failed to appear to an omnibus hearing. A 3-4 finding was made, continued 1 week, and a bench warrant was ordered in Superior Court on February 5th. It is that bench warrant that has resulted in his in custody status in the Thurston County Jail. So he was on pretrial services in violation of his, and then not reporting to not following the pretrial services directions to appear in court. And a bench warrant was ordered. So Mr. West is in custody at the Thurston County Jail because of his lack of his ability to follow release conditions, even though he had defense counsel appointed and was obviously in good communication enough that he was able to schedule a change of plea that was to occur this morning out of custody.
Your Honor, if I may respond, Mr.
Go
West
ahead,
was
Ms. Haygood.
Mr. West was actually held in Nisqually on a Lacey in Olympia case. I believe since January. That's how I was actually able to get a hold of him last week for this change of plea hearing. So as far as I'm concerned, and correct me if I'm wrong, it wasn't a bench warrant or a failure to appear in the traditional sense. He was just held in a different location. It wasn't appearing before the Superior Court in that matter in particular.
But it sounds like as of this moment, he's in custody on an unrelated case in pretrial proceedings.
That is correct.
Yes, Your Honor.
As of Sunday.
And you must be aware that that has implications for his time for trial in this case. I'll say what I frequently say. We're going to get out so among the excluded periods for a case, this case, for the current case, would be proceedings on unrelated charges, arraignment, pretrial proceedings, trial, and sentencing on an unrelated charge.
The judge began articulating his reasoning for finding an excluded period under CRR 3.3, specifically referencing the statutory language that permits exclusion of time when a defendant is engaged in proceedings on unrelated charges. The defense counsel clarified in Spanish that West had been detained in Nisqually on a Lacey case since January, distinguishing this from a traditional failure to appear. Washington Criminal Rule 3.3 enumerates specific periods excluded from speedy trial calculations, including subsection A3 for proceedings on charges in another court, and subsection A4 for proceedings concerning the defendant's mental or physical condition. The Washington Supreme Court in State v. Macchiosi, 188.1.2D706, 2017, emphasized that exclusions must be strictly construed against the government and that courts cannot create non-statutory exclusions. However, the court in State v. Ruffin, 105 WN App. 43, 2000, recognized that delays caused by a defendant's own conduct, particularly willful absences or violations of release conditions, may be attributed to the defendant rather than the state. The judge's reference to procedimientos sobre cargos unrelatados, proceedings on unrelated charges, directly tracks the language of CRR 3.3 at second or 3, suggesting he was preparing to ground his ruling in this specific provision. The defense's clarification that West was detained rather than willfully absent attempted to reframe the narrative away from failure to appear toward circumstances beyond West's control. However, the underlying cause of the detention, West's failure to appear for the Superior Court omnibus hearing, provided the judge with alternative grounds for exclusion based on defendant-caused delay, a principle reinforced in State v. Blee 140 WN.2D703, 2000, where the court held that defendants cannot benefit from their own obstruction of the judicial process. This portion of the hearing reveals the strategic importance of factual framing in speedy trial litigation. The defense sought to portray West as effectively unavailable due to external detention, while the judge and prosecutor emphasized his culpability in creating that detention through non-compliance with release conditions. The outcome demonstrates that Washington courts will scrutinize the causal chain behind a defendant's unavailability, attributing delay to the party whose conduct primarily generated it. This has significant implications for defendants with multiple pending matters. Compliance with all court orders across all cases is essential to preserving speedy trial protections in any single case.
Now, it sounds to me like you just told me that he is in pretrial proceedings on an unrelated. Is that right?
I mean, I think you could characterize it that way. I mean, sure.
Okay. He's not in custody for the city of Tumwater.
Correct, Your Honor.
If Tumwater is not in control of his physical location at this point, they have no more authority than you do to go over there and take him into custody. I mean, I think that has implications for his time for trial rights, and it certainly could be considered a excluded period that would justify extending the time to get his case resolved in Tumwater. I mean, I'll also make this observation. It looks to me like on February 27th, the parties represented that Mr. Clark, or I'm sorry, that Mr. West, through Ms. Clark, wanted to strike his jury panel and enter a disposition. And we made that arrangement, not a trial. He said he didn't want a trial. He said he wanted to dispose of his case. So if he were to come to court on that day that he asked for that purpose, and then tell us that's not what he wants to do anymore, he really wants a trial instead, I would also find that that's a situation of his own making. And having done what we asked him to do, he can't complain that we did what he asked of us. And therefore that would justify extending his time for trial as well.
I'm sorry, Your Honor, can you clarify? Because on the 27th, we struck the panel with the intention to enter this plea for today.
The judge announced his preliminary ruling that an excluded period applied under CRR 3.3, citing West's involvement in unrelated superior court proceedings. He then introduced an alternative, equitable theory that West's request to strike the jury panel and schedule a plea hearing rather than proceed to trial created a situation of his own making that would independently justify extending the speedy trial period. The situation of the defendant's own making doctrine, while not an explicit statutory exclusion, has been recognized in Washington case law as a basis for attributing delay to defendants. In State v. Toller, 61 WN App. 325, 1991, the court held that defendants who request continuances or otherwise manipulate the scheduling of proceedings cannot subsequently claim violation of their speedy trial rights. Similarly, under CRR 3.3 at 8.8, delay resulting from any other proceedings concerning the defendant may be excluded, provided the defendant is the primary cause. The judge's reference to February 27th, when the parties represented West's intent to plead, suggests he was treating the scheduling of this plea hearing as a form of defense-requested continuance that reset or told the speedy trial clock. The judge's dual reasoning, statutory exclusion under SCRR 4303, A3 and equitable own-making principles, provided redundant grounds for his ruling, a common judicial technique to ensure appellate affirmance even if one theory fails. The defense's request for clarification indicated concern that the judge might be treating West's good faith attempt to resolve the case as a tactical waiver of speedy trial rights. The judge's hypothetical, what if West now demanded a trial instead of the plea he had scheduled, revealed his underlying skepticism about the defense's position and his determination to prevent West from exploiting procedural protections to manipulate the court's calendar. This exchange highlights the precarious position of defendants who attempt to negotiate resolutions while preserving constitutional protections. The judge's reasoning suggests that any affirmative request by the defense, even one aimed at case resolution, can be characterized as defendant-caused delay if it alters the original trial schedule. This creates a tension between the right to counsel's effective assistance, which includes plea negotiation, and the right to speedy trial, which can be inadvertently compromised by such negotiations. Courts must carefully balance these interests to ensure that defendants are not penalized for attempting to exercise their right to plead guilty, a right protected under Boykin v. Alabama, 395 U.S. 238, 1969.
Which isn't happening. A couple of unrelated reasons. There would be a need to extend the time so that his case could either be brought to trial or he could enter a disposition if that's what he still intends to do. So I don't see this as a violation of time for trial. I think it's absolutely what the rule contemplates as an excluded period. So based on what's been represented to me about his location and the reason for it, I'm going to find an excluded period is in effect. And if you'd like, I'll reset his case for trial. If you'd like, I'll set his case for a disposition hearing.
Your Honor, can you clarify under which subsection of the rule that you intend to find the excluded period?
Will never actually get released. If they keep telling me I'm going to get released and then I keep getting pushed.
3.3.
And for the record, Your Honor, defense will be objecting to the finding of an excluded period.
I'm also going to say it may be premature. We're at a little, potentially we're speculating on what's happening in this other case, but for purposes of just making the determination now, I'm going to accept those representations. It sounds like we don't really have a final notion yet of what's going on or what the, what his availability will be after this hearing is concluded. All right, so I'll rely on you once you know to tell me what his availability is after his hearing in Superior Court, and then we'll reset his matter on for trial. So just check on that and let me know after.
The judge formally announced his finding of an excluded period under CRR 3.3 and indicated he would reset the case for disposition. Defense counsel requested clarification of the specific subsection, received confirmation of 3.3 generally, and preserved her objection for the record. The judge acknowledged potential prematurity in his ruling given uncertainty about the Superior Court proceedings. The specificity of legal rulings matters significantly for appellate review. While the judge cited 3.3 Tanks AA contains multiple subsections with distinct predicates, subtract 3 for other court proceedings, a 4 for competency proceedings, a 5 for continuances requested by the defendant and others. The Washington Supreme Court in State v. Bonds 167 WN 2D 379 2009 held that trial courts must make explicit findings supporting each excluded period, and that generalized references to CRR 3.3 without subsection specificity may be insufficient to withstand appellate scrutiny. The defense's request for clarification and preserved objection created a record for potential challenge, demonstrating proper preservation of error under RAP 2.5a.3. The judge's general reference to 3.3 rather than a specific subsection, combined with his admission that the ruling may be premature, introduced vulnerability into his decision. The defense's objection, though overruled, ensured that any appellate court would review the issue under the abuse of discretion standard rather than the more deferential manifest weight of the evidence standard. The judge's subsequent qualification that the parties would check back after the Superior Court matter concluded suggested he was treating his ruling as provisional, potentially revisiting it if circumstances changed. This final exchange illustrates the critical importance of precise procedural record-making in criminal litigation. Defense counsel's insistence on subsection specificity and formal objection, despite the futility apparent in context, preserved West's rights for potential post-conviction relief. For educational purposes, this demonstrates that effective advocacy includes creating a complete record, even when immediate success appears unlikely, as appellate courts review only what was raised below. The judge's provisional approach also shows how trial courts manage uncertainty through contingent rulings that adapt to evolving circumstances. Judge found an excluded period under CRR 3.3 due to Brian West's engagement in unrelated Superior Court proceedings, specifically his custody status resulting from a bench warrant in that separate case. The court reset West's municipal court matter for disposition, with parties directed to reconvene after conclusion of the Superior Court proceedings to determine final scheduling defense objection to the excluded period finding was noted and overruled. This case exemplifies the complex interplay between constitutional speedy trial guarantees and the practical realities of multi-jurisdictional criminal justice. The Sixth Amendment and its state constitutional counterparts promise defendants prompt resolution of charges, yet this protection is neither absolute nor self-executing. Washington's CRR 3.3, like similar rules nationwide, recognizes that justice delayed is not always justice denied, particularly when delay stems from a defendant's own conduct or from the necessity of orderly resolution of multiple pending matters. The excluded period framework reflects a legislative and judicial balancing act, protecting defendants from prosecutorial inertia while acknowledging that criminal litigation involves human actors with competing obligations and finite resources. The doctrine that defendants cannot benefit from their own making, whether through flight, obstruction, or even strategic scheduling choices, prevents the speedy trial right from becoming a tactical weapon rather than a shield against governmental overreach. For viewers, the essential takeaway is that constitutional rights exist within procedural frameworks that define their boundaries and conditions of exercise. Brian West's physical presence in the courthouse yet legal unavailability for his municipal court hearing illustrates how formal custody status, not mere geography, determines a defendant's availability for trial. His case also demonstrates that compliance with court orders across all pending matters is essential to preserving procedural protections in any single case, a reminder that the criminal justice system treats defendants as whole persons, not as isolated case files. The judge's provisional ruling, subject to revision as circumstances clarified, further shows that justice is often administered iteratively, with initial determinations giving way to more informed decisions as information develops. This flexibility, while potentially frustrating to litigants seeking finality, serves the ultimate goal of accurate, context-sensitive adjudication. Consider how this case might have unfolded differently. What if West had appeared for his Superior Court omnibus hearing? What if the municipal court had demanded his production rather than accommodating the Superior Court's priority? These counterfactuals reveal how individual choices and institutional practices shape the realization of constitutional rights. As you continue learning about criminal procedure, examine how rules designed to protect defendants can, in application, create pressures that compromise those same protections, and how skilled advocacy can navigate these tensions to preserve client interests.